Is somebody covering for Ms. Acosta?
Your Honor, I think that Ms. Bentz has hired another attorney.
Oh, is that Mr. Wong?
Yes, I don't know that any of us were notified. I haven't received any pleadings, but
Yes, I represent Ms. Bentz, Judge.
Okay, I think we have everybody we need to call the case.
and Your Honor, may I ask who Ms. Preiser is? She's part of this case or another case?
Your Honor, if I might, I am an attorney duly admitted to practice law in New York State. I respectfully request Your Honor's permission to appear this morning. I'm appearing for the grandfather, Rabbi Michael Rasko.
Okay.
I have no objection.
All right. And I can't allow you to ask any questions or participate in the hearing other than just observe, Ms. Preiser.
Understood, and thank you.
You're welcome. Court calls
No
number
objections.
2. Okay, thank you, Mr. Salvador. All right, then with that, Ms. Levy, would you please begin the announcements? And if each attorney would please prompt their client to announce.
Leslie Levy, attorney for the department. I'm here with Katie Schoaf, the caseworker.
Catherine Schoaf, permanency specialist for SJRC Belong.
Chrissy Canop, permanency supervisor for Belong.
Richard Saldivar, attorney for the father, Daniel Roscoe. Mr. Roscoe, will you unmute and announce, please?
Daniel Roscoe, and I'm present, Your Honor.
Brandon Wong for Grace Bentz. Grace, will you unmute and announce?
Grace Bentz, mother.
Alana Pearsall, attorney for the father, Miles Bentz. Mr. Bentz, will you introduce yourself?
Miles Bentz, Paisley's father.
Deborah Fuller, attorney and guardian ad litem for the children. Your Honor, ready?
Jill Roden, Tri-County CASA.
We're here today for a permanency review before final order. Ms. Schoaf, there's no Indian child heritage in this case, correct?
That is correct, sir.
Permanency goal still family reunification?
Yes, sir.
And are the children still in the same placements they were in the last time we were here?
Scarlett has been placed with her father, Daniel Rasko, as ordered at the last hearing.
And is the placement of Scarlett with Mr. Rasko safe and appropriate, meeting her needs?
Yes, sir.
Is it in her best interest to remain in that placement with Mr. Rasko?
Yes, sir.
And Paisley still with Ms. Venegas?
Yes, sir, she is.
Is that placement safe and appropriate, meeting her needs?
Yes, sir.
Is it in her best interest to remain there?
Yes, sir.
Are these placements the least restrictive placements available at this time?
Yes, sir.
All the children up to date on all their checkups?
They are.
Any concerns right now?
No, sir.
Are they receiving any psychotropic medications?
Scarlett is receiving clonidine, 0.1 milligram, and methylphenidate, 10 milligrams twice a day.
How are her behaviors?
They are improving regularly.
All right. And is the review of that medication up to date?
Yes, sir.
Are they in therapy?
Scarlett is in therapy. Yes, sir.
And is it appropriate?
Yes, sir, it is.
Are there any other needs of the children that we need to address today?
No, sir.
And as far as the visitations, is the current visitation schedule for both children appropriate?
No, sir.
All right. What do you want to change?
There are concerns for Scarlett's visitation with Grace Bentz. Scarlett refused to visit with Grace on the last 2 visits and has asked that visitation be discontinued.
That's not what she said.
Hang on, Ms. Bentz. Ms. Bentz, you have to wait until somebody asks you a question, okay? You can't just talk. We're in a court of law. All right. And what are you aware of the reasons that Scarlett feels that way? Has she been able to express those to you or therapists?
Yes, sir. She has expressed those reasons to me.
Do you believe a change in visitation at this time based on Scarlett's refusal and her concerns is appropriate?
Yes, sir, I do.
And what about with Paisley?
Paisley, visitation, I am requesting still be the same.
Are both of the children's educational, well, not Paisley's, but Scarlett's educational needs, are they being met?
Yes, sir, they are.
What happened with the cardiologist referral and the skeletal exam and those things for Paisley?
The cardiologist stated there were no concerns and there was nothing identified or any concerns identified on the skeletal exam.
Is Ms. Bentz in compliance at this time?
In partial compliance.
What does she need to do to be in full compliance?
She has recently started all of her services. We just want to see that with the new service of the anger management and that she's doing with her therapist, Shonda Esparza. And now that she has completed her assessment, that she continue engaging in all services completely.
What about Mr. Bentz?
He is in full compliance.
Mr. Rasco?
He is in full compliance as well.
What do they need to do in order to remain in compliance?
To continue all of their services and continue showing that they have the behaviors have changed for like Mr. Bentz that led to the removal, and for Mr. Rasco to continue building that bond with his daughter and showing that he can provide an appropriate safe home for her.
With the exception of Mr. Rasco, have Mr. Bentz and Miss Bentz fully demonstrated that they've addressed all the concerns at this time?
No, sir.
Would it be safe to return the children to either Mr. Bentz or Miss Bentz at this time?
No, sir.
Has Mr. Rasco fully addressed all the concerns as of this time?
Yes, sir.
You have any concerns about Mr. Rasco's compliance or safety with the child at this time?
No, sir.
Is it in the best interest of the children, both the children, to remain in the temporary managing conservatorship of the department at this time?
Yes, sir.
Ms. Levy, you have any questions for Ms. Schoaf?
No, Your Honor.
Mr. Wong, any questions for Ms. Schoaf?
Yes, Your Honor. Ms. Schoaf, you mentioned that Scarlett no longer wishes to visit with Grace. Can you expand on that?
Yes, sir. For the first time she informed me of it, she stated it was due to when Scarlett is speaking with her mother and Scarlett states something that her mom does not like. She states, "I'm going to call Katie," and tell Scarlett that directly during the visitation. Recently, she stated her mom is making her uncomfortable with the frequent stating of, "I love you, I miss you," and gets upset when Scarlett does not state it back.
And are those behaviors, are those something you don't think Grace can correct by just not telling her daughter she loves her while on the video chats?
We've been trying to make corrections, but she continues stating things that are inappropriate. During the last visit, Grace Bentz told Scarlett that she is making her look bad in court.
And did Scarlett also not mention that she wants to be playing with her friend at that time?
She did.
And is it not correct that she can always play with her friends?
That is correct.
And so isn't that the main reason that the child did not want to see Grace at the prior visit, was because she wanted to play with her friend instead of be with her mom on the visit?
That is what Scarlett told Children Matter. and told her mom as well. But when I called and spoke with her, she stated that was not the reason.
And didn't Mr. Rasco even encourage the child to be on the visit with the mom and that she could go play with her friends at a later date and a later time?
Yes, sir, he did.
And even at the second meeting, this last one that occurred, didn't she also say she wanted to be playing with her friends instead of speaking with her mom?
Yes, she did.
And so Grace is only allowed to speak with her child how often?
Once a week for an hour.
And has she made those visits once a week for an hour?
She has.
And is it not possible to schedule Grace at different times that wouldn't interfere with the child's playing with her friend?
Her friends live right next to her. I do not believe the schedule is the issue.
And so is it something where there can be some form of therapeutic counseling with the child if the child is trying to reject her mother at this point?
She is currently receiving therapy. If you're referring to therapeutic visitation with Grace, that is something that we could consider.
And would you believe that that would be beneficial opposed to just no visits at all?
I do.
Pass the witness.
Mr. Saldivar?
Yes, services.
You broke up. You're going to have to repeat that, I think.
Okay. I'm sorry. Has Mr. Roscoe completed his services?
He's currently engaged in all services. He's completed them, but he continues to be engaged in therapy with Dr. Yates.
Okay. Do you have any concerns for Mr. Roscoe at this point?
No, sir.
And how is the return to Mr. Roscoe's home going with Scarlett?
They're doing very well together. Scarlett appears to be very happy, and during our weekly check-ins and us going there on a monthly basis, all her needs are met, and she does report to be happy in the home.
Okay. Will the department be asking for mediation to decide how this case is settled regarding Scarlett?
Yes, sir.
Pass the witness, Judge.
Ms. Pearsall?
Thank you, Honor. Throughout this case, has Scarlett made outcries against her mother for physical abuse?
Yes, ma'am, she has.
And based on your knowledge, does she struggle with memories and flashbacks from that abuse?
Yes, she does.
And so when she says things like, mom telling me she loves me makes me uncomfortable, does that make a lot more sense considering the trauma that was inflicted on her by her mother?
Yes, it does.
In your opinion, as this child's managing conservator, do you believe it would be in this child's best interest if the visits were either suspended or only based on therapeutic recommendation?
Yes, I do.
Okay. And do you believe it's just based on what Scarlett has verbally expressed or based on everything you know about everything this poor baby has been through most of her life?
Yes, ma'am, that's correct.
Which one?
It's actually both from what she has informed me and from the history that that I am aware of.
Okay. Let's talk about Mr. Bentz. You said that he is in full compliance, correct?
Yes, ma'am.
Okay. And he's finished vast majority of the services, correct?
Yes, he has.
Okay. And some of them, like his parenting, he's done twice just because he keeps trying to do more on his own.
Correct.
Okay. Okay, so his ongoing services are counseling and domestic violence
and anger management.
And is he fully engaged in those?
Yes, ma'am, he is.
And have you received feedback? It's from 3 separate providers, correct?
Yes, ma'am.
Have you received feedback from all 3 providers?
Yes, I have.
And would you agree with me without repeating what they said, that they're just glowing feedback?
Yes, ma'am.
Okay, so he is extremely engaged, doesn't miss a single appointment, and really seems to be learning.
Correct.
Okay. Now, at the last court hearing, I think 2 months ago, the court increased Mr. Bent's visitation to 3 hours with his daughter, correct?
Yes, ma'am.
And are those visits still at 3 hours?
Yes, they are.
Okay, and is that a week?
Yes, ma'am.
Okay. Can you update the court as to how those visits go?
Sorry, those visits go very well. I actually got to go see Miles celebrate her birthday with her. He gets down on the floor. He spends time with Paisley. He reads to her and verbally redirects her. Paisley's very happy and smiling throughout the visit.
Do you have any concerns to starting unsupervised visits with Mr. Bentz?
No, ma'am, we actually are going to be starting 1 hour supervised every week with the 2 hours still supervised for the next 4 to 6 weeks. If that continues well, we'll move into 3 hours unsupervised.
Okay, I think I know what you were trying to say, but I want to clarify.
Okay.
So you are planning starting this week or next week?
This week.
Starting this week, okay. To switch his 3 hour supervised visits to 1 hour supervised and 2 hours unsupervised.
Vice versa, 1 hour unsupervised, 2 hours supervised.
Okay. I'm so glad I clarified because I had no idea what you said. Okay, so 1 hour unsupervised and 2 hours supervised. And
Correct.
then you plan to flip those.
Then I plan after 4 to 6 weeks, if everything continues well, and Mr. Bentz continues to engage, we'll go to 3 hours unsupervised.
3 hours unsupervised, okay. And are you asking today that the court order unsupervised visits for Mr. Bentz in the schedule you just explained?
Yes, ma'am.
Okay, and do you believe that to be in Paisley's best interest?
Yes, ma'am.
Can you tell us why?
For her to continue bonding with her dad, be in more of a less restricted environment so that they can really be able to start having that communication, for Mr. Bentz to show that he can care for his daughter even when not under the microscope of being constantly supervised.
Now, one of the issues in this case has been Grace Bentz kind of continued break-ins and violence at Mr. Bentz's residence, correct?
Yes, ma'am.
And so because of that, Mr. Bentz has had to not only vacate his residence earlier on in the case, but also replace every single item that was either destroyed by Ms. Bentz or stolen from that property.
Yes, ma'am.
Okay. And so have you been to Mr. Bentz's new residence or current residence?
Yes, I have.
And has he worked amazingly hard? Let's try that again in English. Has he worked amazingly hard to replenish and make this new residence child appropriate, literally starting from scratch?
Yes, ma'am.
And is it appropriate and child friendly and just all sorts of adorable for a little girl?
Yes, ma'am. It is appropriate.
Okay. No other questions, Judge?
Mrs. Fuller?
Ms. Schoaf, in regards to Ms. Bentz, her visits go well with Paisley, correct?
Correct.
There's no concerns whatsoever with Paisley.
Correct.
What is your biggest concern with Ms. Bentz throughout this case?
The appropriateness with Scarlett and addressing why the department is in the case.
So at any time during this case, has Ms. Bentz addressed the abuse that she inflicted on Scarlett?
No, ma'am.
And any time during this case, has she dealt with the domestic violence which occurred on both ends between Mr. Bentz and Ms. Bentz?
She has not addressed it to me, no, ma'am.
Okay. No, has she addressed it in her counseling?
She recently started the family violence prevention services, so she has at least taken that step.
Okay. And when you say recently started, we're at the 9-month mark. When did she start the family violence?
She recently had her assessment in April. I have to look up the date for the clarification of which day it was.
So just last month?
Yes, ma'am.
And that is the main reason why we're in this case, is domestic violence and abuse, correct?
Correct.
So isn't it important that that issue is fully dealt with before there's any change in visitation or change in contact with the children?
Yes, ma'am.
And have you gotten any feedback from the counselors that she is attending in regards to the issues she's dealing with?
No, ma'am, I received the assessment. They have not updated regarding her attendance as of yet.
And do you feel that Ms. Bentz fully understood what she needed to address in this case to move forward?
Yes,
Okay. In regards to Mr. Bentz, he is taking a number of classes, isn't he?
correct. Yes, ma'am.
And his visits also go extremely well with his child.
Yes, ma'am.
But one of the main issues with Mr. Bentz was some serious allegations of threats of physical harm to the children, correct?
Correct.
And do you feel that Mr. Bentz has addressed his inability to remain calm in a situation with the children?
I do feel that he is strongly working on it during his sessions.
Okay. And he sees several people, so they're all working with him, correct?
Yes, ma'am.
And you feel that they have indicated that he has made progress in that area?
Correct. Yes, ma'am.
But the department or Belong is still concerned that they're about unsupervised visits immediately, correct?
Yes, ma'am.
But you want to work toward that with Mr. Bentz?
Correct.
Okay. And then Mr. Roscoe, he's doing his services and he's engaged in whatever he's been asked to do, correct?
Yes, ma'am.
Are there any needs that are not being met for Paisley?
No, ma'am.
And she's in a fantastic home that's taking very good care of her.
Correct.
And what do you want to see from first Miss Bentz in this case? And I know we're close to time, Your Honor, but I think the parents need to understand exactly what they need to do. What do you need to see from Miss Bentz?
For her to be fully engaged in all services and address the reasons for removal along with taking accountability with her sessions.
Okay. And what about Mr. Bentz?
For him to continue doing what he's doing, maintain showing that there is not going to be any concerns for threats or violence, and continue addressing the reasons for removal.
And then Mr. Roscoe.
For him to continue doing as he's doing, engaging in his services and providing the safe, appropriate, and happy home for Scarlett and addressing all of her needs.
And when you were asked about Scarlett not wanting to see her mom because she wanted to play, have you discussed with her other options in regards to contact with her mother?
Yes, I have.
And has she indicated that she's willing to try something different?
No, she told me she did not want to.
And Scarlett has expressed to you and to myself in regards to the physical abuse that she suffered, correct?
Correct.
And do you think she's fully dealt with that in her counseling at this point?
No, ma'am.
Okay. So do you think it would be important for her to be able to deal with those issues prior to forcing her to have contact with her mother?
Yes, ma'am.
I'll pass it on to Sean.
All right, we are out of time, and I've got a long docket today. Before I hear from the ad items, does anybody have a question that I haven't heard yet, or feel like there's a piece of information that I need to hear?
Judge, I just have a request for the court, if I could do that now.
Quickly, please.
Judge, I'd like to request mediation regarding Mr. Roscoe and his child as soon as possible, and see if we can settle that portion of the case out. And also ask that the visitation between mom and Scarlett be therapeutically recommended. Obviously, the child's not wanting to visit with her mother at this time. She's the victim of the abuse of Miss Bentz. Miss Bentz has not addressed that yet as to why this case is here. And the child is also subjected to her abuser and hasn't addressed that in her therapy as well, Judge. So I'd ask that only visitation be therapeutically recommended at this time.
Thank you. Ms. Spoler, anything else that you want to add?
And Your Honor, I'm also concerned about the visitation. It's not, as Mr. Wong indicated, it's not just saying, I love you. It's, I love you, I love you, I love you. How come you're not saying it back? I miss you, I miss you, I miss you. How come you're not saying it back? The pressure that she puts on this child in the last hearing saying, you're going to make me look bad in court. This child has gone through quite a bit between Mr. Bentz and Mrs. Bentz. What she's witnessed, what she's been subjected to, and the pressure, you can see it. I mean, you can see it in her when she's on these visits, just being forced to try to say things. And she's told her mom, I feel uncomfortable. Can you stop? And her mom won't stop, and Mr. Roscoe has told Scarlett, this is your chance to talk to your mom. You need to spend this time with your mom. You only see her, talk to her once a week, and she doesn't want to do it. And, I think that we have to respect that at this time, because, I mean, the pressure that she's put on, it's terrible to watch what happens during the visits. And I've watched them since she's been up in New York, and it wasn't like that before. I don't know why the Miss Bentz is, really going full throttle on this now, because the pressure is way too much for Scarlett to handle. So I would ask that any visits in the future be therapeutic visits only or recommended by her therapist. I'm in agreement that Mr. and Mrs. Bentz do very well with Paisley. There's no concerns with Paisley, with both parents, and I'm in agreement with extending the contact with Mr. Bentz. I would just hope that Miss Bentz addresses these issues. These were serious abuse allegations, serious incidents that Scarlett suffered. And she has to understand that this child is dealing with it. And she, she can't pressure her like that. It's very difficult to watch.
All right. Thank you, Ms. Fuller. Ms. Roden?
Yes, sir, just briefly. I do believe both kids are doing well. I have seen them either via Zoom or in person in their placements, as well as talk to the school. Mr. Roscoe's on top of all the stuff for Scarlett. I was able to attend an ARD that was one of the better ARDs that I've ever attended. I think she's got a good team around her. I was able to talk to Dr. Yates regarding visitation for Scarlett just prior to this visit last Thursday that went pretty badly. At that point, Dr. Yates' recommendation was that Scarlett have Zoom contact with somebody that's really able to put some boundaries in place, that's not, afraid to kind of step in, redirect Ms. Bentz, and visits if needed. And she also recommended that we only do visits when Scarlett wants to do visits. So at that point, then Thursday, I believe, is when, she refused the visit. And I know that Mr. Roscoe has a appointment, I believe, this Friday to get her an in-person therapy there in New York. So I think that's something that can be kind of a priority in that therapy, and CASA would recommend that the visitations continue with recommendations of that therapist and in a therapeutic setting, so that somebody's there that can kind of oversee it, help Ms. Bentz, maybe help Scarlett kind of get through whatever is going on, and be able to give some feedback to help their relationship. Paisley seems to be doing good. We're in agreement with the visitation plan that Ms. Schoaf outlined for the court, Your Honor, and we're in agreement with Mr. Saldivar's request for mediation.
Thank you. All right, for the purposes of the permanency review before final order, the court finds there's no Indian child heritage in this suit. The court finds that the permanency goal of family reunification at this point in time is appropriate and in the best interest of the children. The court finds that placement of Scarlett with Mr. Roscoe is safe, appropriate, meeting her needs, and in her best interest to continue. The court finds that placement of Paisley with Ms. Venegas is safe and appropriate, meeting her needs, and in her best interest to continue. The court finds that the children are up to date on all their checkups. Scarlett is receiving psychotropic medications, and her med review is up to date. The court finds that Scarlett is receiving therapy, and that there are no other concerns with the children at this time. Court finds that Ms. Bentz is in partial compliance. Court finds Mr. Bentz and Mr. Roscoe are in full compliance. Court finds that parents are aware of the services they need to continue and the services they need to complete in order to maintain their compliance in this case. Court finds that as of today, it's not safe to return the children to either Mr. Bentz or Miss Bentz at this time, and neither of them have fully addressed the concerns at this time. Seems like Mr. Bentz and Mr. Roscoe are definitely on the right track. Miss Bentz, it seems like you still have some work to do with the acknowledgement of why we're in this case. And I just want to tell you, Ms. Bentz, I've watched you during this hearing. You can't control your reactions. I've already told you not to do that before in previous hearings. You're very reactive to everything that's said. And I think you have some work to do. I can just observe you right now and know that you have some work to do in this case. And I don't want to hear anything, Ms. Bentz. I've already heard testimony. I'm just telling you what I've observed in the last 38 minutes. Court finds that any further visitation between Scarlett and Ms. Bentz is going to take place based on therapeutic intervention and recommendation. I don't want any visits happening until the therapist has weighed in on this. And however the therapist says it needs to happen, based on meeting with Scarlett and hearing what Scarlett has to say, that's how it's going to happen. Court will increase Mr. Bentz's visitation as proposed by the department during this hearing to start to allow some unsupervised visitation in there. I'm going to order the parties to mediation prior to our final trial, which is July 9th, 2024 at 10:30. July 9th, 2024 at 10:30. Is there anything I failed to address? I have to admonish the parents. The state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. If you cannot do so within that time period, your rights to your child are subject to restriction or further restriction as they are now, or termination. All right, I've got to get back on my schedule. Thank you all for your time and your service. Parents, good luck to you. Ms. Bentz, I need you to engage and start talking to somebody. Okay? Nothing further. All parties are excused.
Thank you, Your Honor.
County, Texas, are there any objections?
No, Your Honor.
No, Judge.
No, Your Honor.
No objections.
Then with that, Ms. Levy, would you please begin the announcements, and if each attorney could please prompt their client to announce.
Leslie Levy, attorney for the department.
Catherine Schoaf, permanency specialist for SJRC Belong.
Christy Knott, permanency supervisor for Belong.
Rochelle Acevedo for the mother, Marisol Reyes. Ms. Reyes, will you please announce?
Marisol Reyes.
Jennifer Harris, attorney for alleged father, Mr. Alaquinez, who has now been determined not to be the father, and also attorney for the alleged father. As to the alleged father, I am announcing not ready, Your Honor.
Deborah Fuller, attorney and guardian ad litem for the child, Your Honor. Ready?
Lana Pearsall, attorney for intervener, Ms. Peralta. I am ready. Ms. Peralta, will you unmute and introduce yourself, please?
Janelle Peralta.
Jill Roden, Tri-County CASA.
Kristen Rumley, CASA volunteer.
All right, we've got a not ready announcement for Ms. Harris. We're here today for a final trial. What are the responses to the not ready?
Your Honor, due to the late DNA test and exclusion, I think the department is okay continuing as to the alleged father. We would like to move forward as to the mother with an interlocutory order.
Any other objections to the not ready on the unknown father?
Yeah, we believe it's honestly just in bad faith that Ms. Reyes decided to come up as a new father a week before trial. Having said that, I don't think Ms. Harris honestly is capable of doing due diligence on a person that was just named a week ago. So we are in agreement to allow Ms. Harris more time. However, we are asking for a short, for an interlocutory order today here at the MSA in a very short recess to let us finish the trial. Definitely within 90 days, but hopefully sooner.
Ms. Fuller?
I'm also in agreement to go forward on the interlocutory order on Ms. Reyes. And again, we just received the name last week of another father. And so I feel that Ms. Harris will need some time to explore that.
All right. Has everybody seen the relinquishment?
I have not, Your Honor.
All right. Why don't we take a minute? Ms. Levy, if you could email that relinquishment, please put your email addresses in the chat, because I don't know if Ms. Levy has them all. I want everybody to take a look at the relinquishment. We're going to take a 5-minute recess, and we'll come back after everybody's had a chance to take a look.
Your Honor, I also have not seen the relinquishment. I don't know if Ms. Acevedo can be the one that sends it out.
Okay, thank you. Ms. Acevedo, you have it?
Yes, Judge.
All right, if you could distribute that, and we'll come back and take it up in 5 minutes on the record. Has everybody had an opportunity to review that relinquishment?
Yes,
Yes,
Your
Your
Honor.
Honor.
Any issues with it?
No, Your Honor.
My only concern is that it still lists Mr. Alaquinez as the father, and she has named somebody else. And that is my concern. And that individual was contacted and told about the hearing today, too.
All right, let me see the attorneys in the breakout room real quick. It's going to be room 1. I'll open it in just a moment. Ms. Reyes, I need you to turn on your video, please. Ms. Reyes, if you could please turn on your video and unmute. Thank you, ma'am. All right. We have potentially, we've received information of a potential new father, obviously, Mr. Alaquinez. I signed an order on May 2nd of non-adjudication of his parentage. So we do potentially have new information. Ms. Reyes, I'm going to allow the attorneys to question you regarding this potential new father. I don't know, did you all designate somebody who was going to ask her some questions?
No, Your Honor, but I can do it.
Okay, go ahead, Ms. Levy.
Thank you. Miss Reyes, who do you believe is the father of your daughter?
Well, it would be my boy's dad, my other kid's dad. I was leaving him at the time that I met Angel, so that's why I was sure it was Angel. But I mean, there's no one else than my kid's dad.
So you're positive there's no one else that it could possibly be?
Yeah, I'm pretty sure I'm pretty sure. I mean, I know that I was sure that it was Angel, but I was wrong, obviously. But there's no one else.
I'll pass the witness, Judge.
Ms. Reyes, could you state the name of this individual on the record, please?
Jesse Rizzo.
Any other questions for Ms. Reyes?
Yes, Judge. Ms. Reyes, I'm sorry to be very direct, but I represent an unknown father. So I'm just trying to make sure that there's not anybody else out there. Were you sexually active with anybody else around the time that you conceived?
No.
No further questions, Judge.
Ms. Reyes, you signed the relinquishment with your attorney, correct?
Yes.
Okay. We also discussed this relinquishment at length during mediation, correct?
Yes.
Okay. So at the time you signed it, you understood what you were signing?
Yes.
Okay. And you believe it to be in your children's best interests?
Did you answer that question? I don't know if we broke up or if you didn't answer it.
I didn't answer it.
Okay. I need you to answer that question, Ms. Pearsall.
Ms. Reyes, are you asking the court to accept whether it's this relinquishment or one the court you will sign again in the future because you believe it to be in your child's best interest?
Well, no, I mean, I can't. As of now, yes, but I mean, I know that after this, there's nothing that I can do to change it. But
okay.
Right
Thank
now,
you, Ms.
where
Reyes.
it's at in my life, yeah, it is. But
okay, thank you, Ms. Reyes. No other questions?
Any other questions for Ms. Reyes?
No, Your Honor.
Okay.
No, yeah.
All right. This is what's going to happen, Ms. Reyes. That relinquishment that you signed has the wrong father on it. So I allow the attorneys the opportunity to question you to make sure that we understand to as much certainty as we can who the unknown father is or the alleged father is. We're going to come back May the 21st at 1:30 and conclude this trial. May the 21st at 1:30. Between now and then, Ms. Reyes, I need you to understand something. They're going to change the relinquishment and have you come back in and execute the right relinquishment with the correct information. I'm giving you the opportunity to correct this. If you don't correct it, if you don't work with Ms. Acevedo and get it corrected, then the department's going to proceed on termination grounds that are involuntary. Okay? We're not going to have a relinquishment to accept because I want the correct father written on there. I don't want somebody, I've already signed an order saying that Mr. Alaquinez is not the father. So I'm not going to accept a relinquishment with his name on it. So if you don't work with her and get back in, it's going to work potentially against you. Okay? It's May the 14th. That's 7 days you have to work with your attorney and get this done. I've already told Ms. Acevedo that she is only required to make herself available to you with this relinquishment to a reasonable degree. So if you make her work too hard, if you don't show up when you're supposed to be there, if you cancel appointments, that's to your detriment. All right.
Your Honor, could you order the DNA testing on the alleged father, Mr. Rizzo, just so we can
ordered.
get it started?
It's ordered. And Ms.
Sure.
Harris, you're going to be appointed to represent Mr. Rizzo.
Can I ask something?
Is it something that you should ask your attorney?
Well, I don't know.
What's the question? Is it an informational question or is it legal advice that you're looking for?
I guess I'll ask my attorney.
Okay, ask your attorney. All right, we're way over time anyways. We're going to be back May 21st at 1:30. I'm ordering the DNA test. I'm recessing this proceeding, and we will come back and conclude trial on May the 21st.
Can I ask how much time the court gave us on May 21st?
I put an hour down.
We'll start with an hour. If we can't get it done in an hour, then we'll have to push it back a little bit. But we will at least come back on May the 21st and get as much done as we can in that hour. Okay, thank you all for your time and your service. If nothing further, all parties are excused. And Ms. Reyes, I'm ordering you to be present on May 21st at 1:30. That's the only notice you're going to receive. Thank you.
Thank you.
Thank you.
All right, do you all need to confer before we begin?
All right, Judge. Judge, I don't think so. I know that the mother's relinquishment was filed earlier today, unless I'm not aware of anything else.
Does anybody else need to confer for any reason?
Your Honor, is there a way I can speak to my attorney?
I can give you a couple minutes to do that. We'll put you and Ms. Acevedo in a breakout room.
Oh, no, I'm sorry.
Ms. Pearsall.
Ms. Pearsall, and can I have Deborah Fuller in there also?
Yes, I'm sorry, Ms. Peralta. I wasn't looking at the screen when you were talking. I thought you were Ms. Reyes. Right. All right, and with that, Mr. McKeska, would you please begin the announcements?
Thank you, Judge. Drake McKeska, attorney for the department.
Christy Canal, permanency supervisor for Belong, and I am covering for Ms. Shove, who had a family emergency.
Rochelle Acevedo for the mother, Marisol Reyes. She was on, oh, she is, Judge. Marisol, can you announce, please?
Marisol Reyes.
Jennifer Harris, attorney for the unknown father and for the alleged father, Mr. Rizzo. I'm announcing not ready.
Deborah Fuller, attorney and guardian ad litem for the child. Your Honor, ready?
Alana Pearsall, attorney for intervener, Janelle Peralta, who is present and we're ready. Ms. Peralta, will you please state your name?
Janelle Peralta.
Jill Roden, Tri-County CASA.
Kristen Rumley, CASA volunteer.
We were here May 14th. We had a relinquishment, but we had an issue with paternity. Court commenced trial that day and recessed, and we're resuming today. How does the department wish to proceed?
So, Judge, my understanding is that we are asking the court to go ahead and listen to the prove-up testimony regarding Ms. Reyes's relinquishment and enter an interlocutory order of termination based off that relinquishment and the provisions of the mediated settlement agreement. And then my original understanding, and I could be wrong, so I've admittedly not been handling the case completely since we had mediation, but was that we were going to ask the court to continue the case, not necessarily with an extension, but continue the case. I believe we have some time up until July with the new alleged father, Mr. Rizzo. That would give us time to have him served and possibly DNA tested and those sorts of things prior to the original dismissal date.
Any objection? I know you announced not ready, Ms. Harris. Obviously, I wouldn't be entering any orders as to your client today, but do you object to the interlocutory order?
No, Judge.
No
Any other
objection.
objections? No? All right. Then, Mr. McKeska, you may proceed.
Thank you, Judge. I would like to call Ms. Canop, Judge. Okay, are you the supervisor that's assigned to this case?
I am.
Okay. The parties were able to attend mediation in which Ms. Reyes agreed to provide a voluntary relinquishment of parental rights. Is that correct?
That is correct.
Okay. Judge, let me see. Oh, it's enabled. Never mind. Thank you.
I read your mind.
Ms. Knopp, can you see my screen?
Yes, I can.
Okay, and on my screen, there's an exhibit or document that's been pre-marked as petitioner's exhibit number 1. Do you see that document?
I do.
Okay, and can you please identify that document for me?
It is an affidavit of voluntary relinquishment of parental rights for Marisol Reyes.
I'm going to scroll down to the section where it indicates there's a father for the child, and it indicates that Mr. Jesse Riso may be the father and also contains provisions for an unknown father. Is that correct?
That is correct.
Okay. I'm going to continue to scroll down to the signature pages. Did Ms. Reyes sign this affidavit of relinquishment in front of 2 witnesses?
Yes, she did.
And she also do so in front of a notary public for the state of Texas?
Yes, she did.
Okay, there's a section that is labeled as consent to designation as managing conservator. You see that section?
I do.
Okay, has anyone from the department completed that section?
Not yet.
Okay. As the representative of the department today, if in the event the court accepts this relinquishment, are you consenting to the department being named as or designated as the managing conservator for this child?
I am.
Okay. At the time Ms. Reyes executed this voluntary relinquishment, was she represented by an attorney?
Yes, she was.
Is it your understanding that she had the opportunity to review this relinquishment with her attorney?
That is my understanding.
And do you believe that Ms. Reyes had all of her questions answered regarding the relinquishment?
Yes.
Did the department promise Ms. Reyes anything in exchange for the relinquishment?
No, they did not.
Did the department threaten Ms. Reyes in any way, shape, or form in exchange for the relinquishment?
No, they did not.
And do you believe that Ms. Reyes executed this voluntary relinquishment freely and voluntarily?
Yes, I do.
Do you believe that she executed understanding the full ramifications of the document?
Yes, I do.
Do you believe that Ms. Reyes executed this document believing that it is in the best interest of the child?
Yes.
Okay. Judge, at this time, I'd like to introduce petitioner for 1.
Any objection?
No objection, Judge.
No objections.
Petitioner for 1 is admitted.
Thank you, Judge. Ms. Knopp, can you give the court an update on where Reyes is currently placed?
She is currently placed with Miss Peralta
Okay, and how long has she been placed with Ms. Peralta?
since shortly after birth.
Okay, and do you know approximately how long it's been?
Well over a year.
Has the department had any concerns for the care that Ms. Peralta has received, or that Ms. Peralta, sorry, has provided to Reyna?
There are no concerns.
Okay. What is the department's current permanency goal for the child?
Adoption by Miss Peralta.
Okay. And do you believe that permanency goal is in the best interest of the child?
Yes, I do.
Okay. Have you had the opportunity to observe the relationship between Ms. Peralta and Reyna?
I personally have not.
Okay. I'll pass the Judge.
Ms. Acevedo?
No questions, Judge.
Ms. Harris?
Has your office received any information about any new possible fathers?
Since the last hearing and the mediation, no.
No further questions, Judge.
Ms. Pearsall?
What is the department's permanency plan long-term?
Is adoption by Miss Peralta?
And is that in the child's best interest?
Yes, it is.
Why?
There is a very strong bond between Reyna and Miss Peralta. Reyna has been there. She has been able to provide for all of her cares and needs, and she's been able to provide her a strong, loving, stable home for Reyna.
And you believe specifically the termination of the mother's rights is in the child's best interest?
Yes, I do.
And why is that?
Because Ms. Reyes has not been able to provide a safe, stable, drug-free, violence-free home for Reyna, as Ms. Peralta has.
And has the issue of who could possibly be this child's father been discussed with Ms. Reyes on multiple occasions,
Yes, it has.
both by the department as well as by her testimony under oath in court?
Correct.
Okay. And so the two fathers, according to all the information mother provided, have been the only two options.
That is correct.
There are no other possible people that she's ever had a relationship with who could have fathered this child.
Not according to her testimony.
Now the questions.
Ms. Fuller.
Ms. Knopp, has Ms. Peralta provided Reyna with all the medical and emotional and physical needs during the last over a year and a half?
Yes, she has.
And she was actually the placement during a court-ordered services case as well.
That is correct.
So the child has lived with her for more than half her life.
Correct.
And do you have any concerns whatsoever about Reyna's placement?
I do not have any concerns.
And do you think that the department could have done anything different to attempt to reunify this child with the mother?
No, they could not have.
And you've offered every service under the sun to be able to have Ms. Reyes be able to provide a drug-free and safe environment.
Yes.
And during this case, you were not even able to see where she lived.
That is correct.
And so do you feel confident today that asking the court to terminate her rights is in the best interest of Reyna?
Yes.
Past witness.
Any follow-up, Mr. McCaskill?
No, Judge.
Any other cross?
No, Your Honor.
Any other evidence or witnesses at this time?
No, Judge.
Anyone else?
Yes, Judge. I'd like to call Ms. Reyes.
All right, she's been sworn. Ms. Reyes, Ms. Harris is going to ask you some questions. Please remember that you're under oath. You may proceed.
Ms. Reyes, did you state that you think that Jesse Riso might be the father of Reyna?
Yes.
Have you spoken to him at all recently?
Yes.
And how do you get in touch with him?
My phone. My boys call me and I talk to Jesse sometimes.
Okay. What phone number do you have for him?
You want me to check it? I don't know it. But I have it on my phone.
Yes, can you please look?
Before you give it out over YouTube, Ms. Reyes, I want you to put it in the chat so that Ms. Harris and all the other parties can see it, okay?
Okay, how do I do that?
You see the chat function there on your app?
Oh, hold on.
Let the record reflect that Ms. Reyes has put the phone number into the chat for all parties to see. Due to the confidentiality of the number and a person who may or may not be a part of this suit, the court is going to keep that off the record. All right, Ms. Harris, you may proceed.
Ma'am, did you let him know that he may be the father?
I didn't get a chance to tell him, but he did tell me that someone from CPS did get a hold of him and let him know. So I didn't have to tell him. Y'all already had let him know.
And who is Jeremy Credo?
That's a friend from a long time ago.
Did you also inform him or his family that he may be the father?
No. No.
Do you know why anybody in his family would have any reason to think that he might be the father?
That's a friend from before I got pregnant with my daughter. But he was not a part of my life whenever I did get pregnant with her.
Okay.
But I know he did think that he was, but I told him I don't know why he thinks that that's ridiculous.
Is there anybody else besides Mr. Riso that could possibly be the father?
No.
No further questions, Judge.
Any other cross?
No, Judge.
Just a couple of questions. Sorry.
Go ahead, Ms. Oswego.
Ms. Reyes, I know that you previously testified at the last hearing with regard to the relinquishment. Do you remember that?
Yeah.
Okay. And you previously testified that you have reviewed that relinquishment and you understand the rights that you were giving up?
Yes.
Okay. And then you had to come in and we amended that relinquishment, and you understand that the only amendments that were in there were just to add the, I guess the correct father now, Jesse Rizzo, and the unknown father. And you reviewed that document?
Yes.
Okay. And you understand that once the judge accepts it, it's irrevocable?
Yes.
Okay. And are you asking the court to accept that relinquishment and terminate your rights based solely on that relinquishment?
Yes.
Okay. Does Miss Peralta have a way of getting in touch with you?
Yes.
Okay. And did you provide an email so that if she decides to, she might be able to update you with updates as to Reina?
I don't think so. I don't know. Who am I supposed to give that to?
Okay. And we did discuss that. You need to provide some type of email that you're going to have consistency with. Can you do that and possibly give that to either myself or the caseworker?
Yes.
Okay. There was a portion of the relinquishment that you didn't fill out. It was the medical portion. Is there anything that Miss Peralta needs to know with regard to medical history that you can think of? Okay. And you know that might be very important to Miss Peralta moving forward. So if you can think of anything, or if they reach out to you, can you provide that information? I don't know if you're muted, Ms. Reyes, but I can't hear you.
Yes.
Okay. Thank you. I'll pass, Judge.
Any other cross? Any other evidence? Does everybody rest?
First, Judge.
Rest.
All right, Ms. Fuller, what are your thoughts on the interlocutory termination?
I feel that this is in the best interest of Reina. She's very well taken care of. She's loved by this family. They provide for her needs, her medical, emotional, physical needs, and I feel that they can do that in the future. I hope that Miss Reyes would have gotten the treatment that she needed, but she chose not to, and so unfortunately, this is the only outcome that is in the best interest of the child, because the child cannot be returned to her, and she's in a loving home that has had her, for over 1.5 years. And so, which is more than half of this child's life. So I'm asking that you accept that relinquishment and terminate her on that relinquishment. And I hope the best for Ms. Reyes in the future, but Reina needs to be with Ms. Peralta, and the adoption will need to go forward as soon as we deal with any other possible father.
Thank you, Ms. Fuller. Ms. Rumley, or Dr. Rumley, excuse me.
I agree with Ms. Fuller. I feel that Reina, this is the family that Reina knows, that's cared for her. Ms. Peralta's cared for her, that she's a part of the family. It's very loving. She can provide for medical, educational, emotional, developmental needs. And again, unfortunately, this is where we've gotten to in the case with all the efforts to help Ms. Reyes and, have her be able to be that role. But this is in the best interest of Reina, and I fully believe that she's going to continue to thrive in her environment with Ms. Peralta, and that is her family.
Thank you. All right, for the purposes of the final trial, at this time, the court will find that the mother has submitted to the court through her attorney and to the parties a voluntary affidavit of relinquishment, and that the department has proved by clear and convincing evidence that Ms. Reyes, specifically Marisol Reyes, has, pursuant to Chapter 161.001 B1K, on or before this suit, executed a voluntary affidavit of relinquishment. Court finds, based on the testimony, that acceptance of this relinquishment and terminating her rights based on that relinquishment is in the best interest of the child. Court finds that the placement of the child is safe and appropriate and meeting her needs in her best interest to continue. court finds that the permanency goal of adoption by the placement is in the best interest of the child. The court also makes a finding that throughout this case, Ms. Reyes has not demonstrated that she can provide a safe, stable, violence, and drug-free home, and that the department has made all reasonable efforts consistent with the circumstances to reunify the child with Ms. Reyes, but unfortunately those efforts were not successful. Court will dismiss Ms. Acevedo and her appointment as attorney ad litem for Marisol Reyes, find that she has satisfactorily performed all of her duties. And this termination, again, is an interlocutory order. We're going to recess, and we will come back July 16th, 2024 at 11:30. July 16th, 2024 at 11:30 to resume and take up any issues that may be ripe as far as the father goes. And let's go ahead and put it in the interlocutory order, Mr. McKeska, that the parties are to continue to staff and communicate regarding the alleged and or unknown father that Ms. Harris represents, so that that ball keeps rolling. I don't want to come back in July and not be any farther along than we are now. Ms. Reyes, I know you made a very tough decision. I know it's upsetting for you. I'm sorry for that. Unfortunately, these cases have a timeline, and we butted up against that and moved past it, and here we are. But that being said, I agree with what Ms. Fuller said, that I really do wish the best for you, and really do want to see you address your issues so that you can live the fullest, safest, happiest life that you can. And I hope you can figure it out and get it together. Okay. Mr. McKeska, anything I failed to address?
No, Judge.
Okay. Thank you all for your time and your service. We'll see you back July 16th, 2024 at 11:30. Nothing further. All parties are excused. That concludes our docket for today. Court is streaming via YouTube and Zoom outside of Medina County from Kendall County. Are there any objections? Ms. Wells, are you expecting Mr. Saldivar today?
I'm not too sure. I just found out about the court at 8, so I texted him, but I'm not too sure if he's able to come.
Okay. Well, I think we can probably get through it without him. If you're okay moving forward without him, I am. Okay.
That's okay.
All right, then. Okay, permanency goal at this time still relative adoption with Ms. Wells?
Yes,
And placement there is safe and appropriate in meeting Serenity's needs?
it is.
Is it in her best interest to remain there?
It is.
Is this the least restricted placement available?
Yes.
Is Serenity still in speech and occupational therapy?
Yes, she is.
How's that going?
It's going pretty well. We're taking her every Tuesday and Thursday. They're about an hour-long session, and she's responding really well to it.
She's making progress?
She is.
You believe those therapies are reasonable and appropriate?
They are.
Okay. Is she up to date on her medical, dental, and vision checkups?
Yes, she is.
Any concerns there?
No concerns.
Last time we were here, we had an appeal pending, and that was our barrier to adoption. Is that still the case?
Yes, it is.
All right. Any word on that appeal?
To my knowledge, no. I'm checking the website weekly, and there hasn't been any progress since March 21st of this year.
Okay. Any specific reasonable efforts that Belong has made in order to achieve a permanency goal?
We are just continuing to monitor Serenity's progress in her home. She's doing really well. We have all of the adoption subsidy paperwork filled out, so we're just waiting on that appeal.
So at this point, you've done everything you can do.
Yes.
Sounds like it. All right. Ms. Levy, any questions for Ms. Valdez?
No, Your Honor, but I did also check the status of the appeal, and it looks like the petition with the Supreme Court is just pending a response.
Okay. Thank you. Ms. Acosta?
No questions, Your Honor, and Ms. Levi is correct. It's still pending in front of the Supreme Court, the Texas Supreme Court.
Okay. How do you feel about things?
I think that the only thing holding up the adoption is the that the case is pending in front of the Texas Supreme Court. Once that's resolved, then the case can move forward to adoption. Serenity's been with Ms. Wells pretty much since birth. She's doing well in her care. She's getting everything that she needs. We just need the legal stuff on the appeal end to resolve so that the adoption can go forward.
Okay. Thank you. Dan, is there anything else that I need to hear before I make a ruling? Okay.
No, Your Honor.
Thank you. For the purposes of the permanency review after final order, the court finds that the permanency goal of relative adoption with Ms. Wells is appropriate, safe, meeting the needs of the child, and in her best interest to continue that placement as well, and that this is the least restrictive placement possible. Court finds that Serenity is still receiving speech and occupational therapy. Those therapies are reasonable and appropriate. Court finds that she's up to date on her medical, dental, and vision checkups, and that at this time, the only known barrier to the adoption is still the appeal, which we had pending at our last hearing in December. So we'll be back for our next permanency review, October the 8th, 2024 at 11. October 8th, 2024 at 11. However, if we get that appeal done in between now and then, I'd love to get this adoption the docket and get everything taken care of. So just keep us posted, okay? Okay, well, thank you all for your time and your service, Ms. Wells. Thank you again for always being there. And if nothing further, all parties are excused.
Thank you.
Court is broadcasting and zooming from Kendall County. Are there any objections?
No,
No objection, Judge.
All right, with that, Ms. Levy, would you please begin the announcements?
Yes, Your Honor. Leslie Levy, attorney for the department.
Vanessa De Los Santos, permanency specialist with Belong.
Christy Cannot, permanency supervisor with Belong.
Richard Saldivar covering for Alana Pearsall for the child. Ready?
We're here for permanency review after final order for Stephen. Last time we were here, the permanency goal was unrelated adoption. Is that still the case?
I have it for related conservatorship.
Okay. And where is he placed now?
He is placed in a foster home in Bexar County.
Same foster home he's been in?
Yes,
All right. And that is a non-adoptive placement, correct?
that is correct.
And is this placement safe and appropriate, meeting his needs?
Yes, they are.
Is it in his best interest to continue there?
Yes, it is.
And it's the least restricted placement possible?
Yes.
All right. Is Stephen up to date on all of his checkups?
Everything but the dental, it is scheduled for tomorrow.
Okay. Any issues there?
No issues.
Okay. Is he still receiving psychotropics?
Yes, he is.
Is that review up to date?
Yes, it is.
And how are his behaviors?
His behaviors are great. He's doing really well.
Okay. That's good to hear. It's still, I know back in December, he was behaving well then too. So I'm glad to hear that he's continued that for 5 months plus.
Yes.
Okay. And so since it's relative conservatorship, have you taken him off of TARE and any of those other listings?
I have not, just because we're still waiting for sister to get her apartment.
Okay.
The lease is supposed to be up at the end of May, and then we'll move forward with the home study on sister.
And are his educational needs being met?
Yes, they are.
Still on grade level?
Yes, and passing all his classes.
Did he do PALS already?
I believe so, yes. He has completed the PALS.
Okay. So I had ordered, obviously you all did it based on what you just told me, but I had ordered to start looking at the sister. So do you believe that that's a long-term goal?
Yes, I do.
And it's viable?
Yes.
Okay. And she seems like she's up to the task?
Yes, she does.
Is Steven still in therapy?
Yes, he does attend therapy and engages.
You think that therapy is still reasonable and necessary for him?
Yes, I do.
How far away from getting an apartment is she?
The lease is up, I believe, May 26th.
Okay. And she's just going to get a 2-bedroom instead of a 1, or what?
It'll actually be a 3-bedroom. She'll have a roommate. And then she'll have the extra room for Stephen.
Okay. All right. Ms. Levy, you have any questions?
What grade is Stephen in?
Stephen's in 9th grade.
Thank you. That's all I have.
Mr. Salazar?
Are there any concerns in his current placement?
No concerns.
Are they meeting all his needs at this time?
Yes, they are.
Does he need any orders from this court here today?
No.
Pass the
Anything Ms. Pearsall wanted you to report, Mr. Salazar?
Judge, I have pretty short notes. She's just saying that the placement's meeting all his needs and he's doing very well at placement. She has no concerns at this time.
All right. And for the purposes of the permanency review, after final order, the court finds that the permanency goal of relative conservatorship is in Stephen's best interest. Court finds that his placement in the foster home at this point in time is safe and appropriate, meeting his needs, and in his best interest to continue at this time. Court finds it's the least restrictive placement possible. Court finds he's up to date on his medical and vision checkups, but he has a dental scheduled for tomorrow, May 15th. Court finds that he is receiving psychotropic medications, and that review is up to date. Court finds that his behaviors as of this time are good. Court finds his educational needs are being met. And the only barrier at this time to achieving the permanency goal is waiting for his sister to conclude her lease in one apartment and get another one. Court finds he's still in therapy, and that's reasonable and necessary and appropriate. Find that Belong has made reasonable efforts towards the permanency goal of relative conservatorship in working with the sister and working with Stephen, and also making sure he completed PALS. Our next hearing is going to be October 8th, 2024 at 10:30. October 8th, it appears we have a plethora of attorneys and a paucity of parents. Is anybody expecting their client to be here?
No, Your Honor, no contact with mine.
Same for me, Judge.
No, Your Honor.
All right. Ms. Levy, would you please begin the announcements?
Leslie Levy, attorney for the department.
Christy Knott, permanency supervisor with Belong.
Ona Powell, permanency specialist with Belong.
Jennifer Harris, attorney for the mother. She is not present in order. All announced not ready.
Kathleen Savage, attorney for Joshua Penner, not ready, Your Honor, no contact.
Irene Acosta for the child. Judge, I'm ready.
Jill Roden, Tri-County CASA.
Ms. Harris and Ms. Savage both announced not ready. Was Mr. Penner ever served? He wasn't served out as of February 13th. Do we have any service on him?
Your Honor, I don't see anything in our file indicating service.
I don't have anything in my system either. Then as of this time, I will grant Ms. Savage is not ready as to Mr. Penner. Ms. Gomez, however, was served September 20th of 23. So, and I know she's aware of these proceedings, so I'm going to overrule you're not ready, Ms. Harris. What's our permanency goal at this time?
It is related adoption.
Okay. And is the child still placed with a relative in Medina County?
Yes, sir.
Is that placement safe and appropriate in meeting the child's needs?
Yes, sir.
All right. We don't have any Indian child heritage in this case, correct?
Correct.
All right. Is it, I don't know if I asked you this, is it in the child's best interest to continue in that placement?
Yes, it is.
Okay. And is not up to date on all checkups?
Yes, she is.
All right. Is she receiving any special services?
They are referred her for OT due to her head, but at this time, I'm not sure if they've started her occupational therapy just yet.
Okay. Other than that, are all of her physical and emotional needs being met?
Yes, they are.
We have no parents here today. Do we have any parent in compliance?
No, sir.
All right. Last time we were here, I don't remember who the caseworker was, but caseworker testified to a litany of things that the parents needed to do in order to be in compliance. And it was pretty much everything. Is that still the case?
Yes, sir.
Okay. So at this, as of today, we've got no parent in compliance and really no parent that has actually engaged to this date.
The only thing Ms. Gomez has submitted to was the OSAR and one drug test, well, 2 drug tests. Other than that, she is not in compliance.
Okay. And just for the record, make it clear when I'm talking about no parent, I'm talking about Mr. Rodriguez and Mr. Gomez, not Mr. Penner. But you haven't heard from Mr. Penner either.
No.
Okay. Do you know if he's aware of these proceedings?
He is aware of the proceedings. Per Ms. Gomez, they're all friends.
And Mr. Penner hasn't availed himself to you in any way?
No.
All right. As of today, is it safe to return the child to any parent?
No, it is not.
As of today, has any parent fully addressed the concerns that brought child into care?
No, they have not.
Okay. I had ordered the parties to hold an FGC for Mr. Rodriguez. Did you all do that?
Not at this time. Not as of this date.
Did he ever do the DNA testing?
I'm not sure. DNA testing would have been yesterday. I won't know until they either try to reschedule or produce results.
And I had ordered inpatient at the last hearing as well. I believe for the mother. She didn't go, obviously.
There's an issue with her insurance. We're waiting for her to reach out to her insurance to see if they will cover. And if they don't cover, then the state will cover, but you're correct.
Is mom still visiting?
Mom's last visit was February 15th of this year.
So 2 days after our last hearing.
Yes, sir.
Okay. Miss Levy, any questions for Miss Powell?
No, Your Honor.
Miss Harris?
When did you ask her to reach out to her insurance about rehab?
That was it wasn't myself, it was the OSAR assessment. During the OSAR assessment in April 22nd, her second OSAR, she advised that she had insurance and they instructed her to reach out to her insurance. I believe she called but didn't get through on the line, and she has since not cooperated with me trying to assist her.
What do you mean not cooperating?
I reached out to her 2 weeks ago to ask if she'd ever spoken with her insurance carrier. She cursed me out.
Do you suspect that she is in the midst of a severe addiction?
Yes, ma'am.
No further questions, Judge.
Mr. Saldivar?
Yes, has Mr. Rodriguez indicated that he'd want to sign a waiver of service to this child? I mean, a waiver of interest?
Yes, he has, and it was sent to him.
Okay, and did you instruct him to return that to you if that was his desire?
Yes, sir.
Okay. Do you believe that he understood what he was doing in that situation?
Yes, sir.
Okay, but did he also want to complete DNA before doing that?
He inferred that he would like the DNA test, but he would also like to relinquish his rights if he was found to be the father.
Okay, did he indicate that he wanted to work any services before that?
No, sir.
Okay, pass the witness, Judge.
Mrs. Savage?
No questions, Your Honor.
Mr. Costa?
Thank you. Do you believe that it would be best to stop visits at this time, seeing as her mother appears to be in the midst of a severe addiction and she hasn't had visits since February?
Yes.
Does it sound familiar that Ari is engaged in physical therapy right now for a crawling issue that she was having?
It does sound familiar, but we were more focused on her head, the shape of her head.
And she was seeing a developmental specialist, but that has since stopped, correct?
Correct.
Okay, and she's doing great with Jaleesa at the moment.
She is. Excellent.
And Ms. Gomez and her husband are incredibly protective of Ari. Is that correct?
Yes, they are.
I'll pass the witness, Your Honor.
All right. Ms.
No, Your
Acosta, you want to add?
Your Honor, I would just like to request that the visit stop at the moment. It's the placement and is having to wait every time there's supposed to be a visit to see whether or not mom is going to show up. And I don't think that's fair to them or to Ari. I think it would be best to stop those for the time being. And I would like to request that we be sent to mediation. But other than that, Ari's doing incredible in Ms. Gomez's care. She's well taken care of. She's very, very loved. She's getting everything that she needs. She was having an issue where she was only crawling with one hand. And so they sent her to physical therapy, but that has since resolved. She's still having physical therapy, but the issue seems to be resolving itself. She was going to a developmental specialist, but that has stopped because she's developing normally, and she doesn't have any other issues. So she's doing really, really well in her placement.
Thank you, Ms. Acosta. Ms. Roden?
I don't have a lot more to add other than the things that were in the report we provided, and Ms. Acosta seems to cover it. Between Ms. Acosta and Ms. Powell covered most of it. I agree that Ari's doing well in her placement. I would support Ms. Acosta's request. I think in our report we requested it at least be reduced to the standard twice monthly, supervised by Belong, so that the caregiver doesn't have to continue to wait around and make themselves available. But we would actually support discontinuing them altogether if you would grant that.
Thank you.
Your Honor, I do have a request as well.
Go ahead.
Your Honor, my client is, I think, everybody suspects she's under the effects of a severe drug addiction. I think that Belong expecting her to work out things with insurance to go to rehab is unrealistic and a bit of a cop-out. My client's been indicating that she wants to go to rehab. I would ask that Belong be ordered to find a place for her, let her know that information, be prepared to pay for it, and get that to her for her to avail herself of that if that's really what she wants.
Ms. Powell, do you have the mom, Ms. Gomez's insurance information?
I only know that it's under Oscar. That is the only information I got from the OSAR assessment case manager.
And so the state is telling you that the state's not going to pay for it. When you say the state, who is telling you that?
The OSAR, the assessment worker, case manager. If she has private insurance, they would like for her to rely on her private insurance, or at least see if the private insurance will cover rehabilitation. And if not, then they can assist her with state funding under Medicaid, I believe, for that. So there was a simple thing of just, we needed to know whether or not her insurance carrier would cover. And then I would step in and assist her with getting into rehab. If not, well, either way, I would assist her.
Okay. Court finds, for the purposes of the permanency review before final order, that the permanency goal of relative adoption is appropriate in the best interest of Ari. Court finds that her placement with a relative is safe, appropriate, meeting her needs, and in her best interest to continue. Court finds Ari is up to date on her checkups and that she's receiving appropriate therapy for her physical and emotional needs. Court finds that no parent is in compliance with their family plan of service. As of today, it's not safe to return a child to any parent. And as of today, no parent has fully addressed the concerns bringing Ari into care. Court finds that it's in the best interest of the child at this time to suspend visitation until mother has addressed her drug issues. I'm going to order Belong to assist Ms. Gomez with the OSAR process with state funds. Based on what I've heard today and what I've been hearing throughout this case, I just don't think that the issue is going to resolve with her assistance. So I'm going to make a finding that as of today, it's not possible to assess her private insurance with the mother because it's almost impossible to communicate with her. So I'm going to order that she Belong do that. I'm going to order the parties to mediation. However, you're not required to mediate if one or more parents do not confirm within 24 hours of the mediated settlement date. So if it's set for 10 o'clock in the morning, if you don't have one or more parents confirmed by 10 o'clock the day before, call it off. So that's the order there. We'll be back for final trial May 14th. Sorry, not May 14th, July 9th, 2024 at 9:30. Texas, are there any objections? July 9th,
No
2024
objections.
at 9:30.
No
No, Your Honor.
objections.
Ms. Levy, would you please begin the announcements, and if the attorneys would please prompt their clients to announce. Thank you.
Leslie Levy, attorney for the department.
Christy Knopf, permanency supervisor with Belong.
Ona Powell, permanency specialist with Belong.
Richard Saldivar, attorney for Ms. Connie Ramirez. Ms. Ramirez, will you announce, please?
Connie Ramirez, mom.
Jennifer Harris, attorney for Mr. Velasquez. I'm ready.
Irina Costa, attorney for the children. I'm ready.
Jill Roden, Tri-County CASA.
Sandy Hudson, Tri-County CASA.
Rochelle Acevedo for the father, Ramsey Ramirez. Mr. Ramirez, will you please announce?
Ramsey Ramirez. Bad.
And Your Honor, it looks like my client's got on. Would you like him to announce?
Yes, Mr. Velasquez, would you please announce your name and state your right hand, please? Raise your right hand, please.
Anthony Velasquez.
Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. We are here today for a permanency review before final order. And I'll go over the basics with Ms. Powell. Ms. Powell, is there any Indian child heritage in this suit?
No, sir.
And what's the permanency goal at this time?
Family reunification.
All right. The children are still placed with Mr. Ramirez.
They're now with Mrs. Ramirez on a monitor return.
Okay. And how's that going?
It's going well.
Is it safe and appropriate, meeting their needs?
Yes, sir.
Is it in their best interest to remain in the monitor and return with Mr. Ramirez?
Yes, sir.
How often are they seeing Mr. Ramirez?
How often am I seeing her?
No, Mr. Ramirez. How often is he seeing the children now?
I believe he sees them every weekend.
Are all the children up to date on their checkups?
Yes, they are now.
All right. Are they receiving any special services?
We are trying to get therapy restarted for them.
Okay. Any developmental delays?
No, sir.
And then what about contact with Mr. Velasquez?
I do not believe that there have been any contact with him in over a month or so. I believe he was out of state for a while.
Mm-hmm. What is his current visitation plan?
It is every other Sunday, I believe his was. I can't remember off the top of my head. It's been a while.
Do you believe his visitation schedule is appropriate?
For now.
And are Mr. and Mrs. Ramirez both in compliance with their family plan of service?
Yes, they are. They've completed.
What about Mr. Velasquez?
Mr. Velasquez is still working on his.
Is he in compliance?
He is not.
Why not?
There's a matter of the BIP program. His initial 2054s expired, so we had to get those reinstated. And they're waiting. They should be reaching out to him in the next couple of days. So we got those taken care of. He is not drug tested, but he is attending parenting classes and he has submitted for his psychological evaluation.
Is he cooperating at this time?
We don't have any contact between the two of us.
So he is not cooperating with you?
No.
Do all three parents have a copy of their family plan of service?
Yes, they do.
Is it in the best interest of the children to remain in the temporary managed conservatorship of the department at this time?
Yes, it is.
At this time, has any parent fully addressed the concerns that brought the children into care?
Yes, Mr. and Mrs. Ramirez.
Okay. So why is it in the best interest to keep the case open?
Just simply for the monitor return, which is going well.
So you're asking to keep the case open so you continue to monitor them the mother?
Yes.
So again, I'm just trying to get this clear on the record. What is it that you still need to monitor if she's addressed all the concerns?
That is true. It was just a matter of making sure everything is in place. The children get their therapy. Other than that, there are no concerns. So that is correct. There are no concerns with them in her care.
But you still have concerns with Mr. Velasquez?
Yes.
Okay. All right then. Ms. Levy, questions for Ms. Powell?
Ms. Powell, do you believe that it is in the children's best interest to leave this case open so that child support orders and custody orders can be reached by the parties?
Yes.
I'll pass the witness.
Mr. Saldivar?
Yes. Are you going to order us to mediation to resolve this case?
Yes.
As far as Mr. Velasquez's visitation, is that supervised or unsupervised at this time?
His visits are slated to be supervised.
And who's doing the supervising?
His mother, Betty Velasquez.
Okay. Do you have any concerns with that continuing since he's not drug testing or hasn't addressed the domestic violence at this point?
I do have concerns. I would like for him to submit to BIP and to drug test for us.
Okay. So if you do have concerns, are you asking to change that visitation in any way?
At this point, visitation can be discontinued. I don't think they've had a visit in over a month and a half.
Okay. So are you asking the court to change the visitation to stop that visitation at this time since Mr. Velasquez is not in compliance? Is that correct?
Correct.
Pass the witness.
Ms. Acevedo?
Thank you, Judge. With regard to the timeline, how long do you anticipate monitoring is needed?
I'm sorry, Ms. Acevedo, could you repeat that? You cut out.
I apologize. As far as the timeline, how much longer would the department like to monitor Ms. Ramirez?
We would have liked for 13 weeks is what we initially planned for.
Okay, and how long have the kids been in her care?
They were returned to the monitor return on the 18th of March.
Okay, so how many additional weeks? About 5 weeks, 6 weeks?
Yes, ma'am.
Oh, okay. And the visitation for Mr. Ramirez is going well?
Yes, ma'am.
Does Mr. Ramirez appear to be protective of the children?
Yes, he is.
Okay, and have there been any additional incidents of domestic violence or anything like that?
No, ma'am.
Okay, I'll pass it.
Ms. Harris?
Are you aware that Mr. Velasquez is attending his parenting classes through SA Fatherhood?
Yes, ma'am. He's completed 4 classes.
And are you also aware that he's been doing a separate domestic violence course through the same place?
I was not aware of that.
What does he need to do to get that information to you?
He can email me that information.
Has he ever appeared to be under the influence of drugs when you're around him?
Not when I've been around him, 2
Have there
times.
been any reports of any of the visits not going well?
No, they have not.
Is it your understanding that he's been out of town and that's why he has not availed himself of the visits?
I do know that. Yes, ma'am.
No further questions, Judge.
Mr. Costa?
Thank you, Your Honor. Are you aware of any current court orders that are in place with regard to the children?
Yes, ma'am. I believe Ms. Ramirez discussed with me a court order that was in place before the CPS case regarding custody and visitation.
Do you have a copy of that?
She emailed me a copy last week.
Okay, and is it your understanding that that potentially might need to be consolidated into this case to move forward?
Yes, ma'am.
What else does Mr. Velasquez need to do to be in compliance?
He would need to, well, she said that he's working BIP. I just need proof that he's working services through a BIP program, and he would need to drug test for us.
Okay. With regard to the kids, what happened with counseling? Because I know that they were moved from one counselor to another, but why are we needing to re-engage in counseling?
Just to be in compliance with the court. They are seeing a family specialist, but she's not licensed. And it was discontinued because Ms. Ramirez didn't feel as though any progress was being made with Bluebonnet. But since then, the children's former therapist has returned to Bluebonnet, and we would like for the kids to see her.
Okay, and will they be seeing her after school hours?
Yes, ma'am. We try not to check them out of school. That's been the biggest issue, is getting the time frame together so that they don't miss any school.
Okay, and do you know when that should be able to be accomplished?
Ms. Roden has given me the information, so by this week, I should be able to reach out to the prior therapist and see if she has after school hours.
Okay, and is there anything else that either of them need at this time?
No, ma'am.
Okay, Mom and Mr. Ramirez are taking care of all of their needs at this time, correct?
Yes, ma'am.
And the only holdup right now is that Mr. Velasquez hasn't completed his services. Is that correct? Is that a fair statement?
It is.
Thank you. I'll pass the witness, Judge.
Any further questions from Ms. Powell?
No, Your Honor.
Any other questions for any other witness?
Mind if I say something, Your Honor?
Yes, I do.
Okay.
You need to talk to your attorney before you talk in open court.
Yes, sir.
Ms. Harris, when was the last time have you had an opportunity to confer with Mr. Velasquez?
By text messages, Your Honor.
Okay.
I think he just wants to make sure that everybody knows that he just emailed Ms. Powell his attendance with domestic violence and parenting.
Okay. That'll be fine. Mr. Velasquez, I'm always hesitant to let clients who are represented by attorneys speak in open court because that's for your protection. Okay?
Yes, Your Honor. Completely understand. She resolved it right now. Thank you.
Okay, good. All right. I'm glad. Okay. Ms. Acosta, anything you want to add?
No, Your Honor, not too much. I know that the kids are fine at home with Mom and Mr. Ramirez. It's unfortunate that Mr. Velasquez was out of town so long and wasn't engaging in his services, but it's good that seems to be getting back on track. I do want mediation ordered so that if there's anything in the current custody orders that needs to be tweaked, we can make sure that we do that now. I think that would be the only thing, and just making sure that the kids get re-engaged in counseling. I know it's really, really busy with extracurriculars and getting them one place to the next. And I think that that's important right now since they've been going through this case and they've transitioned back home. But with regard to visits with Mr. Velasquez, I don't want to say that he shouldn't have any visits. I just want everyone to make sure that he's complying with his service plan prior to the kids having visits with him again. I want to make sure that that's being done because I think that it's really important, especially in this case in particular where there was domestic violence that was an issue, that be taken care of. But I do know that when they were having visits with them, they were enjoying the visits. So I don't want to take something away from them if that's what they want.
Thank you. Ms. Hudson?
Yes, sir. CASA agrees with the opinion Ms. Acosta and Ms. Powell have given. We are concerned that Mr. Velasquez is not drug tested and would like to see that happen before visits begin. I'm happy to hear that he has started his services. He has not returned any phone calls or texts of mine since January, and I would love if he would communicate with CASA. We think the kids are doing very well with Ms. Ramirez and Mr. Ramirez's help. And the kids are very, very busy with extracurricular activities. So scheduling that counseling to the best of their availability would be considered very good for them. But the kids are doing great, and we think that Ms. Ramirez is doing a wonderful job with them.
Okay. Thank you. Court finds for the purposes of the permanency review before final order that there's no any child heritage in this suit. The permanency goal of family reunification is in the best interest of the children. Court finds the children are placed with Mr. Ramirez on monitored return, and that placement is safe and appropriate, meeting their needs and in the best interest to continue. Court finds that their continued contact and visitation with Mr. Ramirez is appropriate as well, and in their best interest. Court finds the children are up to date on their checkups, and they're not receiving any special services. But I am going to order that we get that therapy started ASAP and that it be scheduled in a way to not impact the family too much. So whatever we can do that is logistically efficient with regards to the extracurricular activities and everything else they have going on, that's what we need to do. Court finds that Mr. and Mrs. Ramirez are both in compliance with their family plan of service. Court finds that Mr. Velasquez is not in compliance. I understand you're out of town for a while. You've obviously got some work to do. You need to get to work on that, especially that BIP, because I don't think anybody's going to let this case in without you having that taken care of. You got to call Ms. Powell back, Mr. Velasquez. You got to stay in constant touch with her because she's your liaison. She's your conduit to this case. So please don't neglect her calls or emails or whatever. Answer them immediately.
Yes, sir. I hadn't received a call.
Okay. I'm going to set Mr. Velasquez's visitation schedule at this time to once a month for 1 hour supervised by the department. But if he gets engaged and addresses these concerns, that'll make me feel better about some of these safety issues that I've heard today. We can extend that. We'll go to 2 hours or longer if you all think it's appropriate. But we need to address these concerns before we just jump back in like everything's normal. Court finds that all parents have a copy of their family plan of service. And then I'll make a finding at this time. It's in the best interest of the children to remain in the temporary managing conservatorship of the department. Although Mr. and Ms. Ramirez have both addressed the concerns, and it's safe to return the children to them, the children still need some services. And so it's in the best interest to keep the case open, as well as because Mr. Velasquez is still working his services. I'm going to order Mr. Velasquez to submit to a UA prior to his next visit. And then I'm ordering the parties to mediation. The next hearing is going to be July 9th, 2024 at 10 a.m. July 9th, 2024 at 10 a.m. I'm really proud of Mr. and Mrs. Ramirez for the progress you've made in this case, for getting to this point. It's a lot of work, and I know that you both have put in the time and the work and the effort, and I'm just admonishing you to continue that. We're still in it. I don't like to keep these cases open any longer than are necessary, which is why I was asking the questions that I was asking. Sounds like we needed to do a little more monitoring, but I'm really proud of the progress that you both have made to this point. Good job. I have to admonish all the parents anyways that the state of Texas gives parents in CPS cases 12 months initially to provide a safe, stable, violence, and drug-free home for your child. If you cannot do so before that 12 months is over, your rights to your child are subject to restriction and or termination. We've obviously made some great progress in this case. It doesn't look like you're going to need all that time. So good job. Anything I failed to address?
Judge.
Yes.
My boys do go to counseling. They go once per week with Brenda Bolsterbaum at K-Star. And I wanted to see if I can have permission to keep having them do their therapy through Miss Bolsterbaum at K-Star.
Why don't you all, I don't know enough about the specific services they're offering there to know if they meet the requirements of what was testified to today. So just talk to Ms. Powell. It sounds reasonable to me, but we don't need to get in all those details on the record about the therapy, but I do want you all to discuss it. So I'll go ahead and add Ms. Levy to the order that within the next 48 hours that you all discuss the counseling that the boys are receiving and to see if it complies with the needs of the children at this time. And if it does, then I would say continue to do that. Okay. All right. Thank you all for your time and your service. If nothing further, all parties are excused. With that, Ms. Levy, would you please begin the announcements?
Leslie Levy, attorney for the department.
Vanessa De Los Santos, permanency specialist with Belong.
Christy Knott, permanency supervisor with Belong.
Jennifer Harris, attorney for respondent mother, Ms. Soto. Ms. Soto, can you unmute and announce your name, please?
Raven Soto for a mother.
Kathleen Savage.
Richard Soto,
Attorney for the respondent father, Mr. Humphreys.
Richard Sullivan, attorney for the child.
Rochelle Savello for the interveners, Mr. and Mrs. Humphreys. Can you please announce?
Chris and Karen Humphreys.
Ms. Levy, how does the department wish to proceed today?
Your Honor, the children are on a monitored return. There is not much time left under the statute, but the department would prefer to monitor it for the full amount of time remaining, just because the children have only been back for a few weeks. I believe that would also give the parties time to mediate so that the mother can receive final orders, which may help her and the children. So we are asking for a brief reset for the amount of time remaining.
Is there any objection?
No objection, Your Honor.
No objection, Your Honor.
No objection.
No objection.
Okay. Well, that was my understanding. and I just wanted to confirm it. We've got June 6th available at 11:30, and your dismissal date is June 20th. So that's about as far as we can go to monitor before we either commence or do something else. So that will
Your
be
Honor.
the date. Go ahead.
Could we get an authorization for mediation or an order to mediate?
Yes, that was the next thing I was going to do was order you all back to mediation or to mediation in the first place. I don't know if I've ordered it before. And do that prior to that June 6th date. Anything else that we need to take up today?
No, Your Honor, but can we put the attorneys in a breakout room to schedule that mediation? There's a lot of us. That might be the best use of our time.
I agree. All right. Do we need anybody else to stay in the hearing?
I don't think so, Your Honor. Maybe just the supervisor and the worker.
Okay. Then for everybody else that's here, we have continued the trial to June 6th, 2024 at 11:30 to continue to monitor Ms. Soto. And the attorneys are going to go into a breakout room right now and pick a mediation date. So if you're not on that list of folks in the breakout room, you are welcome to leave and get your mediation date from your counsel once they've had some time to put that together. And I think that's everything. So everybody else, thank you. You're excused, and the breakout room is open, and you're all just welcome to leave whenever you're done. Okay.
Riley Sherrod Buckner, permanency specialist for the case.
Christy Cannot, permanency supervisor with Belong.
Jennifer Harris.
Richard Sullivan, attorney for Mr. Navarro. Not ready.
Jennifer Harris, attorney for Ms. Salinas. Ms. Salinas, can you unmute and announce your name, please?
Daisy Salinas.
Rochelle Acevedo, attorney for the child.
Well, we're here today for a permanency review before final order. Miss Sherrod Buckner, is there any Indian child heritage in this case?
No, sir.
All right. What's the permanency goal at this time?
Family reunification.
And where's the child placed at this time?
With Miss Salinas.
All right. And how long has the child been there?
About a week.
Have you been there since the child was placed?
Yes, sir. I was there on Monday.
How's it going?
Everything is going good. Violet, which is the daughter, she seemed to be getting adjusted to the place. She's not really doing a lot of crying anymore. She does go to her mom when instructed to. So there is no concerns for us.
Do you think the placement is appropriate and safe in meeting her needs?
Yes, sir.
It's in her best interest to remain in that placement with Miss Salinas at this time?
Yes, sir.
Is it the least restrictive placement available?
Yes, sir.
And is she up to date on all of her checkups?
Yes, sir. Her medical and her dentals. Yes, sir.
Is she receiving any special services or any kind of medications?
No, sir. Not at this time.
Does Miss Salinas work at this time? Is Violet going to be going to daycare?
Yes, sir. At this current time, she does work and her schedule does vary. So her mom, Miss Debbie, is in the home. That is also helping her. I did explain to Miss Salinas once she's ready for us to do daycare, she just needs to let me know about the daycare provider, so I'm able to put those things in place for her.
How long does the department intend to monitor Miss Salinas?
I did speak to Miss Salinas about that. I do believe I explained to her for another 13 weeks or so.
So that's going to be close to the dismissal date of August the 10th.
Yes, sir.
Okay. And Miss Salinas is in compliance?
Yes, sir.
Is Mr. Navarro in compliance or in contact with you?
No, sir.
Is Miss Salinas in a relationship with Mr. Navarro?
No, sir.
Has he had any contact with a child that you're aware of?
No, sir.
So your representing to the court that as of today, it's safe for the child to remain with Miss Salinas, and she's addressed the concerns, but you need to continue to monitor the placement.
Correct. Yes, sir.
Is there any other service that you want the mother to complete?
No, sir, not at this time.
And so you believe it's in the best interest at this time for the child to remain in the temporary managing conservatorship of the department?
Yes, sir.
Excuse me. Miss Levy, do you have any questions?
No, Your Honor.
Sass?
No, Judge.
Mr. Salvar?
No questions, Your Honor.
Ms. Acevedo?
Judge, just a couple. I think just for clarification, you wanted mom to provide the daycare information to you?
Yes, sir. Yes, sir. Yes, ma'am. I did explain to her once she finds a daycare provider, we would then reach out to our individual that handles daycare because we have to just make sure that they're able to take our daycare voucher that we do give them. Yes, ma'am.
Okay, so should she provide multiple?
Yeah, so whichever one is available, because I know I did explain to her there has not been a lot of openings because in the beginning she did explain to me that she did not want childcare at this, current moment. So I did speak to her today and she would just kind of let me know, well, maybe me having childcare would be kind of good. So I told her that's fine. We'll kind of just kind of look together because I know she lives in the area. So I told her if she has any issues with finding childcare, I will be able to assist her. But if she know any, daycare that just off the top of her head, I can give them a call to kind of get their, I think it's the EIN number, I think that they have to provide for us to run into the system just to make sure they're acceptable.
Okay. And do you need an actual court order or the department is going to pay for that?
It would need to be in the court order. So we don't have any issues with trying to get the child placed in childcare. Yes, ma'am.
And then has she been named as a medical consenter?
Repeat that question again.
Has mom been named as a medical consenter?
Yes, ma'am. I just have to follow with the court. Yes, ma'am, she has, which I explained that to her yesterday.
And as far as her items, have those all been sent to her?
Yes, ma'am. So the day of placement, I did give her everything that was given to me by placement. The only thing that I did not receive was the life book. I did reach out to the foster parents on last Friday and then yesterday, Monday, which they have not contacted me back regarding the life book. But I will continue to kind of reach out to the foster parents.
Okay. Thank you. Pass judge.
Any other questions for Ms. Sherrod Buckner?
No, Your Honor.
Any other witnesses?
No, Your Honor.
No, Judge.
No, Judge.
All right. What do you want to add, Ms. Acevedo?
I was able to see Violet. She's, I saw the home. I'm sure it's a transition for everyone. Mom has, now 2 little ones in the home. But she has a lot of hands there. She has her mom, she has her sister there. So it seems to be going well. As far as the transition, I think it was a very thoughtful process. I was, in contact with Mr. Bruckner at length. And so the process was slow and steady, and mom never deviated. I'm sure she got a little frustrated with how slow it was, but we got to the end and here we are. Placement was last week. I think there's a little bit of monitoring, but we took the time that was needed for that and where we all feel comfortable. I think mom's doing well. Like I said, I'm positive it's a hard transition. Everybody's gonna have to get used to double diapers, but it's being done.
Okay. Then for the purposes of the permanency review before final order, the court finds there's no Indian child heritage in this case, that the permanency goal, family reunification, is in the best interest of the child. Court finds that Violet is placed with Ms. Salinas and a monitor return. The placement is safe and appropriate and meeting Violet's needs and in her best interest to continue. Court finds this is obviously the least restrictive placement available. Court finds that Violet's up to date on her checkups and she's not receiving any special services or medications. Court finds that it's in the best interest of the child for the department / belong to continue to monitor this placement, probably right up until the dismissal date based on Ms. Sherrod Buckner's testimony of about 13 weeks. Court finds that Ms. Salinas is in compliance with her family plan of service. Mr. Navarro is not in compliance with his family plan of service. Court finds that as of today, the parents are not in a relationship, and Mr. Navarro has had no contact with the child. Court makes the finding that it's safe to return the child to the mother, and she has addressed all of the concerns in this case. However, the court needs to monitor the placement. Department needs to monitor the placement to ensure that all of the child's needs are being appropriately addressed by the mother. I'm going to order the parties to mediation. If you can't get Mr. Navarro there, then I don't know how much good it's going to do, but I will order it. And then your final trial is set for July 9th, 2024 at 1:30. July 9th, 2024 at 1:30. Ms. Levy, is there anything I failed to address, or Levy, excuse me, anything I failed to address?
Will you enter that order for daycare as well?
Yes, so ordered. I knew there was something else. I was trying to think of it. And I have to admonish you, Ms. Salinas, the state of Texas gives parents in CPS cases 12 months to demonstrate you can provide a safe, stable, violence, and drug-free home. If you cannot do so, your rights to your child are subject to restriction and or termination. Obviously, you've taken that seriously. You've made a lot of progress in this case. So I'm very proud of you and the work that you put in and the work that you've done to get to this point. I just encourage you to continue to do that. Case is still open. Obviously, you've got your child in your home with you, so things look a lot different. Just stay on top of it and continue to do what you're doing, okay?
Mm-hmm.
All right. Anything further from anyone else?
No, Your Honor. Thank you.
Okay. I'll see you all back July 9th at 1:30.
Yes,
Nothing
thank you.
further. All parties are
Thank
excused.
you. Thank you.
We're here today for the status hearing, and I know this is a unique case, but we've got some things to cover that we talked about when we were here last time. First of all, is there any Indian child heritage in this case?
No, there isn't.
All right. And I'll just jump right ahead. Did you all hold a family group conference?
Yes, we did.
Okay. And considering the circumstances, did you develop a permanency goal?
Yes, we did.
And what is that?
It's relative adoption and relative conservatorship.
With the Hendersons?
No, we are trying to locate other family members at this time.
Okay. So we ruled the Hendersons out?
Yes.
Okay. And what else did you discuss at your family group conference?
Really wraparound supports that Zane is needing. He's had a lot of hospitalizations since coming into care. So really trying to develop a plan moving forward of what supports we can get for him.
Okay. And where is he placed at this time?
He's at the Touchstone campus, but right now he is hospitalized at Clarity.
Touchstone is in Bexar County?
It's in Guadalupe County.
Guadalupe County, okay. Is that placement safe and appropriate, meeting his needs?
Yes, it is. There have been concerns though that he hasn't really acclimated to the program. This has been his fourth hospitalization since being placed there.
Are you looking at other placements?
Clarity has a partial hospitalization program at that campus. And so we are trying to figure out once he gets discharged, if he can be admitted into that program. And then he could go to campus from 8 a.m. to 4 p.m. and then go home to Touchstone in the evenings.
Okay. So is it in his best interest to remain at Touchstone at this time?
Yes.
Is he up to date on all of his checkups?
Yes, he is.
Is he receiving any psychotropic medications?
Yes, he is.
Is the review up to date?
It is. And Clarity just changed his medication from what's listed on the report. He is now on Latuda, 40 milligrams.
How are his behaviors? I mean, what's the reason for the hospitalizations?
The first few hospitalizations were due to suicidal ideations, trying to run away from campus. More recently, his behaviors have gotten a little bit aggressive with staff. He's been punching walls, wanting to contact family members that are not on his call list right now. And whenever staff have put him in containments to make sure he's not hurting himself, he'll start biting and kicking them. This last hospitalization, he had also made some homicidal remarks about a younger student on campus, and a mental health officer had to be called out.
Okay. Do you believe that the care he's receiving in his hospitalizations is appropriate to address these concerns?
Yes, I do.
All right. I think the answer to this is clear, but you believe it's in the best interest of Zane to be in the temporary managing conservatorship of the department belong?
Yes, I do.
And is this the least restrictive placement available consistent with the circumstances?
Yes.
All right. And do you believe that family plan of service that was created for Zane is narrowly tailored?
Yes, there isn't a family plan of service. There wasn't any legal guardians to create one for.
But you said it contained wraparound services, right?
Yes.
Okay. So do you believe that those services are narrowly tailored?
Yes, I do.
Okay. And you believe they're in his best interest?
Yes.
Okay. Mr. McKeska, any questions?
No, Judge.
Ms. Savage,
No questions, Your Honor.
what do you have to report at this time?
Zane is definitely struggling. I believe this is hospitalization number 4 or 5. I know the medications have frequently changed because he's also going to different hospitals. So I'm hopeful that if we can get him into this partial hospitalization program, it will give him a consistent treatment plan where hopefully he can stabilize. He does like Touchstone. He is wanting to go back there, but ultimately he does want to be in a foster home. And so that's not even something we can look at right now when the reality is he's going to hospital every week or 2 weeks at this point. He does voice wanting to have still some sort of connections with family, but we have not been able to find appropriate family. So hopefully we can continue that search because I think that support, he's like really desiring connections and support like any child. And we just don't really have that for him right now. So I do recommend him going back to Touchstone at this time. I think at least he's here where we can keep an eye on him versus him going to RTC somewhere much further. But hopefully that hospitalization plan program would be in his best interest for sure.
Okay.
And we do have a meeting for Monday with you, Your Honor, but I think that's going to be contingent on if he's out of the hospital or if he's not started that program. So I believe that's at 10. So I will touch base with placement to see if we're still going to be able to facilitate that. Probably Friday to see where he's at.
Okay. Well, just let me know. That's fine. All right. Any other requests or orders?
No, Judge.
Okay. Then for the purposes of the status hearing, court finds there's no Indian child heritage in this suit. Court finds that the permanency goal is relative adoption or relative conservatorship. Court finds that as of today, no other appropriate family members have come forward. Parties were able to hold a family group conference to create a service plan for Zane. The services in that plan are narrowly tailored in Zane's best interest and will be orders of the court. Court finds that he is up to date on his checkups, his psychotropic review is up to date, and that his placement is safe and appropriate, meeting his needs. As far as best interest goes, it sounds to me like we don't really have any other options at this time. This is the least restrictive placement available, but it would be in his best interest to continue to explore other placements until something more appropriate comes available. It's good to know that Clarity has that part-time program, so hopefully we can utilize that. Court finds that the care he's receiving is appropriate to address the concerns with his behavior, and that it is in the best interest of Zane to remain in the temporary managed conservatorship of the department / belong. Anything I failed to address, Mr. McKeska?
No, Judge.
All right, we'll be back for this initial permanency hearing August 13th, 2024 at 2. August 13th, 2024 at 2. All right, well, Ms. Savage, just let me know when you find something out. I mean, even if it's Monday before the meeting, I'll be here. So if we need to move it back, we can move it back, but hopefully we can have that. All right, thank you all for your time and your service. If nothing further, all parties are excused. That concludes the docket for today.
Thank you, Judge.